is a senior associate of the firm, advising clients on all aspects of corporate and commercial law, including capital markets, mergers and acquisitions, banking and finance law, and foreign investment law. With that, Himali, it's over to you. I hope all of you benefit from this very timely discussion. Thank you.
Thank you, Radhika. Good afternoon, everyone. Thank you for joining this webinar on the Personal Data Protection Act. As most of you may be aware by now, the Parliament of Sri Lanka enacted this law in March of this year. And this act has significant implications consisting of both legal and compliance obligations for companies in Sri Lanka that process personal data. Up until then, Sri Lanka didn't have any statute of general application which protected personal data other than limited statutory confidentiality obligations which were imposed on certain regulated entities such as banks and finance companies. However, now data has become a valuable commodity, as you all know, and it was inevitable that data protection and privacy be regulated in our country, and Sri Lanka finally passed this law to recognize the value of personal data and to protect it. Now, the Personal Data Protection Act is broadly based on the GDPR, which is the General Data Protection Regulation of the European Union, which, as you know, it is quite stringent in nature. Now, my colleagues Shanaka and Amanda will be providing you with a general overview of the law in today's presentation, and they will also discuss in detail, to the extent that time permits, the essential elements of the law and the obligations which are imposed on companies that process personal data. Now, given the broad definition of the term data processing and data processors, you may find that the companies you're part of do fall within the definitions and need to comply with the legal and compliance obligations of this law. As the obligations are serious in nature and require extensive preparation time, we advise companies to commence their compliance process immediately. Some of our clients have already started this process. I will now hand you over to Shanaka Gunesekera, who is the head of our Data Protection and Privacy Practice Group, and Senior Associate Amanda Perera for the discussion. As Radhika mentioned earlier, if you have any questions, please type them into the chat box and we will take them all at the end. Thank you, and over to you, Shanaka.
Thank you, Himali. I think you all can see my screen, right? Hello. Can one of you confirm, please? Thank you. So as Himali mentioned, this is Sri Lankan personal data protection law is inspired from GDPR, and back in 2019, the first iteration of the bill came in, and thereafter, I think there were certain rounds of public sector view gathering, and there the stakeholder views were taken into consideration. And it's the third iteration, if my memory is correct, which that was presented to the Parliament, and with certain modifications at the committee stage, it was finally enacted in 19th of March with a transitional time period provided. And the reason for that is, as Himali mentioned, there is a lot of work is required prior to for any institution to be in compliance with the enactment, and that's the reason for the transitional time period. With that in mind, just to broadly cover what does the personal data protection law try to address, it's as you are aware, up to the introduction of this particular law, personal data, there was no restriction of in using it, and data being a commodity, and the rights of the individuals had to be balanced, and that's why the concept of personal data protection was introduced in European Union and elsewhere. So this enactment grants rights to data subject, imposes obligations on entities like you which process personal data. It regulates direct marketing and also provide for a separate enforcement authority, and impose severe penalties for any transgressions. To understand the enactment, there are many defined terms, but there are few fundamental terms that we need to sort of have an idea prior to understanding what the law is, and so that we can have at least a generic understanding of the law. So if you take these key terms one by one, personal data. Personal data is practically anything which can be used to identify an individual, directly or indirectly. And here it's also important to note that sometimes on the face of it, it may not amount to personal data because the word indirectly is also used here. Even though on the face of it, the data subject or the person those particular data may not amount to personal data. If from that particular data, sufficiently interested and determined person can ascertain an individual, then it would amount to personal data. As for an example, let's say there's a call log at the reception, and if you want to figure out who has made that call in the organization, a sufficiently interested and determined person in the organization can easily figure out, okay, who worked at this particular point of time, and then can easily relate that call log to the person who was on duty at that time. So that data, the call log, although in isolation may not help you to identify an individual, but sufficiently interested and determined person can ascertain an individual easily from the existing other data by combining it with other data. It doesn't mean that the sufficiently interested and determined person does not mean an investigator, or you try to engage in a voyage of discovery to find out by combining a lot of other information whether this can be used to identify individual. It doesn't go to that extent. The test is sufficiently interested and determined person. That means an ordinary person. With the ordinary person in the shoes, ordinary person who's looking at data, whether he's able to identify an individual. Data subject, that's a natural, that data subject means any human being who is a natural, in other words, a natural person. And the enactment also gives protection to deceased. So the heirs of the deceased can exercise the rights of the deceased for a period of about 10 years. And it's also important here, the word at the end of the definition, it says natural person, alive or deceased, to whom the personal data relates. So this is also important. It's not the mere fact that you are processing personal data doesn't mean that enactment is applicable, but I have to caution there. I'm not saying that if you have personal data not to comply with this enactment, but I'm just trying to point out the concept that enactment becomes applicable when you take personal data relating to an individual and relate it to that individual. What does it mean? Say, for example, I send you an opinion, and then you consume the opinion only to figure out what the opinion is. But the moment at the bottom of the email, there you would have my name, contact number, email address, and the rest of the contact information. That is my personal data. But the moment you consume the opinion to figure out who is this lawyer, has he given me a correct opinion, at that point you are relating my personal data to the opinion. So then you are processing personal data and you are relating it to me. Only at that point the enactment becomes applicable. So that's important to understand. That's an important, I would say, theory aspect that needs to be understood. But realistically, if you are processing personal data, you must always take steps to comply with the enactment. But just to explain, only at the point of relating it to an individual, the enactment will kick in. Then there is among the category of personal data, there's a separate carved out portion, which is called a special categories of personal data, also known as sensitive personal data. Some of the examples are set out here. The racial data relating to racial or ethnic origin, political opinions, religious or political beliefs, biometric data, genetic data, health data, and the details pertaining to convictions or criminal proceedings, sex life and sexual orientation, and any data relating to a child. All this data is considered sensitive data or special categories of personal data. The purpose is there are more there are more stringent requirements that are applicable in processing sensitive data compared to ordinary data. And with regard to a child, under the ordinary law, child is a person who is below the age of 18, but for this enactment, it's below the age of 16. Processing, that is the term that is used in this enactment to define acts that you do in relation to personal data. So that, and the processing is defined in such a way that anything and everything that you do in relation to personal data would amount to processing. That is collection, storage, that is mere storage sitting in your servers or simply archived. You may not be using it at all. But so long as you are in possession of it somewhere, then it amounts to processing. Then the two persons that the enactment try to regulate are controller and processor. If you first take the controller is the person who determines the purpose of processing and the means of processing. This is called why and how question, meaning, let's say, for example, you are a bank or you are a hotel, and then you would determine for the purpose of, let's say, opening a bank account or even accommodating a guest, I would need this type of information. So there you are determining the why question as well as the how question. That means you are determining why I need this data, and then you would also be figuring out, okay, this is how I would be processing that personal data. This is how I would store. These are the type of people with whom I would share the information, like that. So if you are the person who's determining why and how question, then you are called the controller. That means you are the principal decision maker, and the all obligations of a controller under the enactment would become applicable to you. A processor is a person who processes personal data for and on behalf of a controller. That means if we for the convenience of understanding, if we replace the word processor with a third-party service provider, that would be a practically accurate replacement of the term, because the say, for example, you retain a cloud service provider or data analytics service provider or payment gateway service provider. In any of those instances, you may be passing personal data that you have obtained for your purposes with such third-party service providers. So any third-party service provider that whom you onboard to help you on any aspect of your business, and if that third-party service provider in that process access personal data that you have collected or you are the controller of, then that third-party service provider is called a processor. So not all third-party service provider, only those whom you would onboard for the purpose of helping you with any aspect of data processing. When I say helping, it doesn't necessarily mean that you have onboarded that person for the purpose of helping any act of data processing, but you may have onboarded for a different purpose. But in that process, you may have to share personal data that you have collected with such third-party service provider. In that case, you have a processor on board. And it's also important to note that processor is always a third party. That means a person who is not within your hierarchical control. So your employees, your consultants, as the case may be, though, with regard to consultant, definitely your employees, they are not processors. They are part of the controller itself. Then, as you have seen the two terms, processor and processing, we need to also understand the difference between these two terms. Grammatically, it looks like one is the verb, one is the noun, but that's not the case, and that's not the but for the purpose of the enactment, there's a drastic difference between the two terms. Processing, as I explained, it's any act that you do in relation to personal data. And a processor is a person, a third-party service provider for if you use that term for the purpose of convenience, a third-party service provider that a controller onboards for the purpose of helping any aspect of data processing. So if a controller does not take a third-party service provider on board, that means controller itself is doing all acts of processing. So it doesn't mean that therefore only the processor who processor is the only person who processes personal data. That's a completely wrong impression to have. It's the both controller and a processor process personal data, and any act of processing done by any one of them is called processing. That's the difference between the two terms. Then to figure out whether how this enactment becomes applicable to any controller or processor, that is a company like yours, there are various grounds that are set out in the enactment, and if you fall within any one of them and if you process personal data, then your actions are governed under the enactment. So if you are an entity which processes personal data wholly or partly within Sri Lanka, then your actions are governed under the enactment. Or if you are a controller or processor which is a resident in Sri Lanka, or is registered or incorporated or established under the Companies Act, or offer goods or services to any data subjects in Sri Lanka, or monitors the behavior of data subjects in Sri Lanka. If you fall within any of these grounds and process personal data, all your actions are governed under this enactment. Broadly speaking, without trying it to a particular sector, any company or any institution which engage in commerce, we could see broadly three categories of personal data that you would have. You would have your customer data, you would have your third-party data, and you would have your employee data. Third party here means the third-party service providers that you onboard, let's say, for example, janitorial service provider. And for the purpose of dealing with that janitorial service provider, you may have contact information of that particular service provider. Even that contact information, even if it is official contact information, would amount to personal data. So that's a point that also we need to keep in mind. Even if a particular set of information relating to an individual, it's considered business contact information, not his personal contact information, is still considered personal data, because using that official business data of relating to that individual can be identified. Hence, even when you process such information, that act of processing also amounts to processing personal data. So with that in mind, if you first take the first category of data, customer data, the two important issues to note there. The first one is it applies to all existing data. And that is to say, not just the data that you would collect after the enactment comes into being, but rather even data that you have collected up to this point. Why is that? Because, as I said, the definition of processing includes even a mere act of storage. So why you would keep the mere act of you keeping archived would amount to act of processing. So any prospective act of keeping data in your servers or in your computers after the enactment become enforceable would amount to an act of processing. So even if we take other data, say for example existing customer data which is not archived, but you would be using it, let's say for warranty purposes or any other purposes, all those processing of personal data after the enactment becomes enforceable would be governed under the enactment. So all existing data therefore has to be migrated into a data protection compliance environment. And it's also, you also need to keep in mind, this is not an enactment which is tied up to citizens. In other words, even foreigners can exercise their rights under the, even foreigners can exercise the rights granted to data subjects under the law against you. So that's, so it's any person. It doesn't matter with the person's personality is irrelevant. Person's nationality is irrelevant. Then for the purpose of understanding your obligations, first you need to figure out whether you are a controller or processor. As I said, the person who determines the how, why and how questions would be the controller, and if you are not the person who determined that, but you have been onboarded to assist certain aspects of processing, then likely that you are a processor. So depends on your activities, you could be either controller or processor. It's also important to keep in mind the concept of control and process is tied up to the activity, not the entity. That means with regard to a particular transaction itself, with regard to certain aspects of that transaction, you could be a controller, and with regard to the another set of aspects of the same transaction, you could be a processor, because the controller and processor is tied up to the activity, not necessarily. In other words, once you are a controller, it doesn't mean that you are always a controller. So with that in mind, some examples of a controller is, say, for example, when you are offering services or you are creating accounts or user registrations, when you are handling information for consumer complaints or direct marketing activities, or you're doing automated decisions or monitoring of customer payment behavior, or collection of information of employees. All that, in all those instances, if you are the person who determine the purpose and the means, then you are the controller. And instances where you could become a processor is, say, for example, you are selling on a third-party platform such as Daraz or Amazon. Then with regard to certain aspects, you are the processor. And or else you have been onboarded as an outsourcing entity to process personal data, or to provide data analytics service, provide data analytics. Then in that scenario, likely you could be a processor. Or if you're acting as a cloud service provider or payment gateway service provider, in that scenario also, with regard to those limited aspects, you could be a processor. So bear in mind that, again, as I said, when you are a cloud service provider or you are a payment gateway service provider, it doesn't mean that with regard to everything that you do, you are a processor, because with regard to certain things, you may be determining the purpose and the means. If so, with regard to those things, you could be the controller. With that in mind, how do you figure out, how do I approach, how do I try to comply with this law? And for the sake of convenience, we have tried to sort of like explain it in this particular way. You have to first figure out your purpose. That an organization, as we said here, may have millions of purposes. And you have to identify the purpose, and then identify the lawful basis, identify lawful basis set out in the enactment, and then confine processing of personal data to that particular purpose. To explain further, the freedom, let's say, for example, direct marketing, up to this point of time, for that particular purpose, you could have collected any data, you could have done anything with it. Now, once you identify that particular purpose, the enactment set forth certain lawful basis on which you can process personal data. And whatever the purpose that you select, you must be able to tie it up to one of the lawful basis in the personal data protection law, and you have to select the appropriate one. So, and after selecting the lawful basis, you must limit processing of personal data for that particular purpose to the in a way that you will not be processing personal data in a disproportionate manner. So the enactment, we will be going into each aspect of these three stages in detail to explain further, but to give a further information on this, lawful basis, with regard to lawful basis, enactment set forth about 6 grounds, 6 lawful basis. And remember, we also talked about sensitive personal data. If you are processing sensitive personal data, in addition to selecting a lawful basis, you will have to also satisfy one of the additional conditions. Say, for example, if we take your purpose, as I said, is direct marketing, and you ascertain the lawful basis. Let's say the lawful basis is consent. And that for that particular purpose, if you have to process sensitive personal data, then apart from having a lawful basis, which is consent, you will have to fulfill another additional condition. And when you, after doing so, you will have to ensure that the data that you collect is adequate, relevant, and proportionate to that purpose. So the freedom that you had to collect any amount of personal data that you prefer is completely taken away. So you have to be able, you should be able to objectively justify that this information, that is X, Y, and Z information, let's say name, contact, name, address, and the mobile phone number, is mandatory for the purpose, objectively mandatory for the purpose of processing this, for the purpose of fulfilling this particular purpose. And it's also important that the adequacy means not only limiting yourself to the required amount of information, but also processing information that is required for that particular purpose. What does it mean? Say, for example, if you are to make a particular decision, and if for it to be correct, if it requires A, B, and C information, but if you process only A and B and makes the decision, that violates the adequacy principle, because without the C factor, when you make the decision, it might have a detrimental effect on the data subject. So therefore, adequacy means not only limiting yourself to the adequate data, but also means mandatorily processing the required data. So with that in mind, if we go to the each aspect little bit more in detail, identification of the purpose. Now, you may have different business functions, and under each business function, you would have various activities. As I said, direct marketing, use under sales department, you would have direct marketing, user preference or behavior tracking, account creation, consumer complaints, customer profiling, and under the human resource department, again, you would have various purposes. So once you identify this purpose, then you have to go to the enactment and figure out which lawful basis should be used for each activity. And again, we would be explaining a little bit more detail some of these grounds. These are not the full list of grounds. There are more grounds, but we have taken things that are usually applicable. When you are selecting a ground, there are certain principles that are applicable. Selection of a ground has to be done very carefully. And when you select a particular lawful basis, you must necessarily document it with the reasoning why that is selected. And one basis is not given priority over the other. In other words, there is no catch-all basis. Say, for example, there is consent here. The fact that you can't use the consent as the basis. Okay, if I have the consent, I should be able to do anything. That's not the way the data protection. That's not how the data protection concept works. We would explain in detail what this consent means here. So that's not the consent you and I usually know. It's a completely different concept of consent. So each ground, when it comes to each ground, it must be selected where it is appropriate. And if you select the wrong basis, then your entire act of processing would become unlawful. And as I said, when you're selecting these grounds, you also have an obligation to select the least intrusive basis. What does it mean? It means, say, for example, you have the contract as a lawful basis, and then you have a legitimate interest here as another lawful basis. And if selecting contract would allow you to collect only A, B, and C personal data, but if you select legitimate interest, you are able to collect more than A, B, and C. You must necessarily select the contract because that's the least intrusive option that allows you least freedom. This is the concept of data minimization that has been built into the concept of data protection. And legal obligation is where you have some sort of a legal obligation such as EPF, ETF, or even financial transaction reporting purposes, then this would be usable. So private sector, again, there's a certain application of this particular lawful basis, but this public interest and legal obligation is mainly applicable for public authorities. And it is also important to note that we have highlighted here the word necessary, which is appearing with regard to almost every ground. The necessity here means it's more than useful, but not absolutely essential. To explain further, say, for example, you have a particular ERP system in place for the time being, and that ERP system requires when you try to process an application, you must fill in A, B, and C, the particular fields. So therefore, you may try to interpret and say, for the purpose of me to feed in this information or to process the application, I need all this information. That's not necessity. Necessity here is an objective necessity. So objectively considering, if you are to fulfill that purpose, you need A, B, and C information, then only those information you can collect. The fact that you have come up with a particular system, it requires more than A, B, and C, that's not, as I said, necessity. So when you are approaching the requirement of necessity, what needs to be kept in mind is that objective necessity, that is more than useful, but not absolutely essential. If you take some examples under each of the grounds that are listed here, necessary for the purpose of a performance of a contract or to enter into a contract with the data subject, this is the ground that is most likely to be applicable in most of the instances when it comes to a private entity. That is to say, even to application processing or processing of payment information, or even sale of goods, services, loyalty programs, warranty, delivery purposes, all this would be based on a contractual arrangement. So in those instances, appropriate ground would be contract. And it is also important to note that, as I said, when you select the lawful basis, you must necessarily document it, because the enactment requires you to demonstrate compliance. It means if the data protection authority questions saying why this particular lawful basis, you should be able to prove it by way of documentation. This is why I have selected that particular basis. It also means that from time to time you'll have to revisit, because probably in certain instances, without you even knowing, you may have ended up in processing, you may have ended up in doing things that you did not originally plan. So this is called function creeping, and that, to prevent that from happening, necessarily you must end up in reviewing your processes from time to time. And if there is and if you have deviated from the original purpose, and if it is not compatible with the original purpose, then you will have to again restart the process where you ensure that the current activity is in line with the enactment. Then if you take the legitimate interest as a ground, as I said earlier, should not be selected if you have any other ground as a rule of thumb. The reason is legitimate interest, as you can see from the word, is a very wide term. So you should select that only if you don't have any other basis, because this is considered the most intrusive option. And as a result of it, when you are selecting this ground, the enactment necessarily requires you have to balance your obligations or your requirements against the rights of the data subject. That means you have to do what is called a legitimate interest assessment, meaning my use of this ground will not unfairly or prejudicially affect the rights of the data subject. And only after doing that assessment, you should be looking at using this ground. Sometimes when you do that assessment, you might even have to do a data protection impact assessment, which we are going to talk about in this presentation. But so if we take some of the grounds that some of the instances that can be put under that can be done under the ground of legitimate interests, one is prevention of fraud, a network or information security, or loyalty schemes, provision of after sales services. So please bear in mind these are broad examples. So this doesn't mean that every time you do this, legitimate interest is the appropriate ground. These are under the circumstances. These are some of the wide examples that we could think of. If you take the legal obligation as a lawful basis, you would have if you have a mandatory KYC requirements such as banking corporations, the Financial Transactions and Money Laundering Act would be applicable to almost every organization. And any reporting that you have to do there, and then EPF, ETF purposes, or gratuity enactment purposes, or shop and office enactment purposes. If we have to process any personal data, then the appropriate lawful basis is the legal obligation. So there another the factor that is important is that when it comes to a particular purpose itself, sometimes more than one lawful basis would be applicable, meaning for the purpose of entering into employment contract. So there are the lawful basis would be this. But in the process, when you are, because the employment contract is a matter which is also governed under the Law Shop and Office Employees Act, and the enactment would require certain mandatory information to be collected. And therefore, that legal obligation as a lawful basis would also be applicable. The consent, again, we are going to talk about this in a little while in detail. Usually, this is given the unique nature of the consent which is used in this enactment, it can be used in only in very limited instances. Some of the examples that are can be cited here, some of the examples that can be cited here: promotional or marketing activities, customer preference tracking. So there, the appropriate lawful basis would be consent. Then we also mention now, if after selecting the lawful basis for the particular purpose of processing, and if you also need to collect sensitive personal data such as genetic data or data related to children or health data, then apart from having one of these lawful bases, you also need to fulfill an additional condition, meaning you have to select the additional condition appropriate to the sensitive data that you collect. Say, for example, now ethnicity could be required to be collected under certain forms promulgated under the EPF ETF Act. Ethnicity is sensitive personal data. So your lawful basis for collecting any data, there would be legal obligation if it is for the purpose of complying with EPF ETF enactment. And then, but it may also require ethnicity. You need to fulfill an additional condition, which is again a legal obligation as set out here. So the legal obligation set out here is different to legal obligation set out under this additional condition, because here it would be the lawful basis. This is applicable only if you process sensitive personal data. So some of the grounds, very few grounds actually, are sort of repeated. Some of the lawful bases are also repeated as an additional condition. But that is not to say it is the one and the same, but rather as an additional condition when you process sensitive personal data. Some of the other additional conditions are necessary for the purpose of any written law. Again, here something like a KYC requirement or any other requirement under any written law which requires you to process sensitive personal data, and establishment of defense or legal claim. So that means, say, for example, for the purpose of defending you, if you have to process certain sensitive personal data, then this would be the additional condition. And let's say, for example, you are processing certain data that a person has published in his Facebook public profile, then if it amounts to sensitive personal data, this could be your additional condition, which is the data subject has manifestly made it public. Say, for example, he has openly declared that he's of this particular political ideology. Assuming that information is required for your purpose, if you do so, then this would be an additional condition apart from having a lawful basis. Then again, consent is listed here again as an additional condition, and consent here and consent as an additional condition, same definition is applicable. So with that in mind, if you try and understand what is the concept of consent that has been introduced in the enactment, all this information are information directly extracted from the enactment. But if I am to explain in a way practically that a person can understand, when you enter into a contract, necessarily there is a contractual consent comes in. But that's not the consent here. The consent here means an instance where a human being, a data subject, can have absolute free will over the decision that he makes. What does it mean? Say, for example, you are a seller of a particular product. Customer walks into a store and say, I want this product. And for that purpose, for the, let's say, warranty information, you say, please give me a name, address, mobile number. And now you have to select an appropriate lawful basis for this. You might think, OK, let me select consent as the appropriate lawful basis. That would be incorrect, because why? The appropriate lawful basis would be for the purpose of entering into a sales of goods contract. And what's wrong in selecting consent there? If the customer wants that particular product, even though you may not be the only seller of that product, he has no option but to give the consent. And that consent is not the consent which is encompassed here. They are, as I said, absolute free will, meaning he should be able to give or not give consent and not have any consequences coming in his way. Therefore, that's why we put only limited examples here. Say, for example, marketing. You say, I want to promote some of my products because now that you have become a customer of mine. There, the customer has the absolute free will to say yes or no. Because if he says no, there is no consequences coming to him. There are no ramifications. He can exercise the decision at his absolute discretion. And that's the consent which is mentioned here. So that can be written consent or affirmative consent. In other words, an overt action. If there's by way of an overt action, if he gives the consent, that again is valid consent. But remember, as I said, it's not the consent that you and I have naturally understood. And in the context of a contract, sometimes you see these service providers or sellers of goods on the overleaf, you mention so many terms and conditions, and you end up in saying, OK, you consent to me contacting you for marketing purposes X, Y, and Z. And that is also now completely prohibited once the enactment becomes enforceable, because if you are using consent as the appropriate lawful basis, you must do it so in a very overt manner, meaning his attention must be drawn to that. He should be able to understand when he gives the consent, OK, I'm giving consent for this particular activity. So it can't be already pre-ticked. It has to be, he should by overt action, he should be voluntarily selecting it. That's what the absolute free will means. So ideally, in a data protection compliance environment, consent document therefore is separate. You may see this when you try to log on to European websites or even American websites, you get these banners popping up with regard to cookies. Apart from the essential cookies, you have other cookies which may tracking cookies that are being used. And there your consent is specifically sought. And then you get the option of either selecting it saying yes or no. And that's the consent which is encompassed here, and that's the concept we have borrowed from GDPR. And it's also important that when you use the consent as the lawful basis, to have a record of the consent. It's also important in the context of the consent that it can't be just part of your terms and condition. As I said, it has to be separate. It has, if it is part of a bigger document, that you can't impose the consent. What does it mean? Say, for example, he has to sign off on the contract, and you insert the consent as one of the terms. Then he has no option. When he signs the terms and condition, you are imposing the consent on him. And that's why it has to always be separate and not mingled with other things which he has no option. And because of that absolute free will, consent is necessarily tied up with withdrawal of consent. So at the point of obtaining the consent, you have to tell the customer, if you want at any point of time, you can withdraw the consent. And that is why it is you can give the consent only when he has absolute free will. So if you select consent where the contract is the appropriate lawful basis, what would happen is when he comes back and withdraw, you are not able to process that information. That's because you have selected the wrong lawful basis. So if it is for the contract, that is why it is important. You must select contract as the lawful basis. I think that would give you adequate information as to what amounts to consent. Taking into looking into some of the other aspects of data protection as a controller, what you have to do. There are certain other obligations: accuracy and completeness, integrity and confidentiality, retention time period, transparency, internal controls and procedures, and honoring the rights of the data subject. If we take one by one, accuracy and completeness. Now, up to this point of time, you didn't have an obligation when you collect personal data that you have to ensure it is accurate and it is complete. But with the enactment comes into being, you have to ensure, you need to have a process in place to ensure that the data that you collect at the reception or at counters are accurate. So there has to be policies and processes that need to be put in place to ensure that happens. And you have to also ensure you have processes and procedures in place to identify errors and to rectify them. And further, the processes and procedures in place to, from time to time at regular intervals, to update it so that you keep a record of accurate information, not outdated information. Please also bear in mind this particular obligation is tied up to one of the rights that are given to data subject, which we are going to talk about. It's called the right of rectification, meaning he is now under the law entitled to come to you and tell, my information, my address is wrong, correct it. Then you are given a statutory time period to correct that and go back to the customer and say, I have implemented it. And part of this obligation is also that inaccurate or outdated data should be erased or rectified. So that means, depending on what you do, you will have to come up with, as I said, processes and procedures to ensure that you do update your information, or at least on regular intervals. So it doesn't mean that at any given point of time, you need to have accurate data. It means at least at reasonable regular intervals, you cross-check the data, rather you check with the customer whether this is accurate. Let's say once every 6 months, you send a SMS to the customer or a particular message saying, click on this link, go to that, and if your information has changed, please update. Integrity and confidentiality. And this is also called the security principle. This means when you process personal data, you have to have appropriate organizational and technical measures to ensure unauthorized or unlawful processing of personal data, or loss or destruction or damage of personal data. That means where encryption is the recommended option, you must carry out, you must deploy appropriate encryption mechanisms. Where pseudonymization is appropriate, you have to do pseudonymization. Where the data can be processed without relating it to an individual, anonymization. Where anonymization is appropriate, you must do anonymization. And it also means that you need to have access control. Say, for example, previously HR department, let's say everybody in the HR department had access to certain information, but you will have to now figure out whether everybody needs to have access, only certain individuals need of the HR department, or certain designations, whether I should limit access to certain designations. That is also one of the requirements. In other words, that's what it means by access controls. So as an organization, when you try to comply with the security principle, therefore, you need to have a comprehensive policies on security and what measures you are going to adopt. This includes not only online security, also physical security. That means your physical premises. Do I have adequate and under the circumstances appropriate physical security measures, CCTV to the entry protection systems, all that. So depending on what you do, appropriateness of a particular standard would vary. So it is likely that with the enactment comes into being, there might be regulations also coming into this. Regulations or rules might also come into this regard. But this is one of the areas where your IT and physical security teams would have a huge role to play. Retention time period. Again, up to this point of time, you didn't have any restriction as to how long you can keep the data. There were requirements as to keeping data, say under certain enactments, under the Shop and Office Employees Act or the Financial Transactions Reporting Act. It requires certain records to be kept up to a certain number of years. But there was never a requirement that you must delete it after the purpose is fulfilled or after the mandatory retention time period. But with this enactment comes into being, your freedom to keep the data as long as you want is completely taken away. Now, right at the beginning, when you identify a purpose, when you identify a lawful basis, at that stage itself, you need to identify the retention time period. Or at the very least, you need to identify the criteria based on which you would define the retention time period. And then you need to also set forth that in your privacy notice, which is the document that is where you are going to give the info. That's the document using which you will be giving information to your customers or even to employees. We are going to talk about that privacy notice and that aspect a little bit more detail. Having said that, in identifying the retention time period, it's also important to note that sometimes for the purpose, you may have to keep the information only for 1 or 2 years. But bear in mind there are other aspects such as prescription ordinance, which allow, let's say, customer, if it is a written contract, he can sue you within any time from the date of arising of the cause of action. He can sue you within 6 years. So if you delete the data within 1 or 2 years saying that purpose is fulfilled, you may be exposed to a legal action without any defense. So when you are defining the retention time period, those factors should also be kept in mind, and any other legal obligations. Transparency. Now, you may have seen when you're accessing foreign websites, or even sometimes even like something like a web pages such as Amazon or even AliExpress, you have this document called privacy notice coming in. And that's the document which tells customer who is interacting with that organization, okay, this is how I process your personal data. And that's by doing so, what they are in fact fulfilling is this transparency principle. And in addition to that, it also has the aspect of that you have to ensure you respond to the request of the data subject in the exercise of their rights under the law. So both aspects are included under the concept of transparency. If you go a little bit if you go into a little bit more detail with regard to the mandatory information, the enactment set forth in a particular schedule all the information that you have to give at the point of or before collecting personal data. And this is what is typically included in a privacy notice. So the name and contact details of a controller, contact details of the data protection officer, if any, that you are going to talk about, intended purpose for collecting. Now, this is why right at the beginning, you need to identify the purpose. And the privacy notice, if you read a privacy notice of any organization, you would find out they have listed out a lot. And that's because they have identified right at the beginning different purposes, and they have ensured they have listed them out. And it doesn't mean that once the privacy notice comes, is drafted, that's the end of it. So you have to update it from time to time because your purposes you may add in, change. And that's why sometimes from Google and all these entities, you get the email notification or when you try to access them saying our privacy notice has changed. That's because they may have added a new purpose, or there may be other legal requirements that have come in. So, and the ability of the data subject to withdraw the consent where the consent is the appropriate basis, that must be mentioned. Recipient or third parties with whom personal data may be shared. That means any processors with whom you share personal data or any third parties. And period of retention, information regarding cross-border data flow, that also we are going to talk about. Existence and procedure for exercising the rights of the data subject. Now, enactment grants rights to data subject. We are going to talk about that. And whatever the mechanisms and procedures that you are going to come up with to enable those rights, you must set forth in the privacy notice. And ability of the data subject to file a complaint to the Data Protection Authority. And if you are if certain personal data is not provided to you when you ask for, and if it results in certain ramifications on the data subject, that must also be mentioned. And decisions on automated processing, and information on disclosures to regulatory authorities such as returns to tax authorities and stuff like that. Then one of the unique natures of this enactment is that you would see, except in a very few enactments in the country, no other enactment apart from imposing obligations tell you how to do it. Meaning, okay, you need to have X, Y, and Z type of a mechanism in place to comply with the enactment. The data protection as a concept, you may have heard this term called privacy by design or security by design, meaning what they want, but the concept requires you to comply with the data protection from the beginning itself. So this is not an enactment that can be passed on to a department. The very nature of the obligation is such that from the reception to all the way to the board of directors, everybody has a role to play. So the data protection has to be woven into the very fabric of the organization. So these concepts that are set out under the concept called data protection management program, this is the word that is used in the enactment, is to ensure that. So broadly, what it requires is that you must ensure your entire organization is transformed to a data protection compliant environment by default. Meaning it's not a job of a particular officer. As I said, from the reception to the collection counter, everybody has their procedures which is in compliance with the data protection law. So if we take the concepts that are sub-concepts that are integrated under this data protection management program as set out in the enactment, data protection management program should be designed on the basis of the structure, scale, and volume and sensitivity of processing. Provides appropriate safeguards based on impact assessments. Establish internal oversight. Update based on periodic monitoring and assessments. A mechanism to receive complaints, conduct inquiries, identify breaches, integrated into the governance structure, and maintain duly catalog records. So when you take all those things into consideration, as I said, this means the entire organization is transformed from A to Z. One aspect, though, that I would like to highlight here is the duly catalog records. If you if somebody asks you a question when it comes to compliance with the data protection law, what are the three important principles? First, documentation, second, documentation, third, documentation. Why is that? It requires, the enactment requires you to demonstrate compliance. That means every aspect of the way you should have documentation by way of policies, procedures, rules, guidelines, and any other internal mechanisms. Everything should be documented so that organization, the compliance by the organization can be ascertained from the documents themselves, as opposed to questioning a particular individual or many individuals for that matter. That's what internal controls and procedures obligation means. This is the most important feature of the enactment, which is granting rights to the data subject. That means the moment you take personal data to your hand, data subject or the human being to whom that data relates acquires certain rights against you. If you take one by one, right of access, it means, say for example, after the enactment comes into being, one of your former employees write to you and say that, and ask the question, do you process my personal data? And if so, give me the confirmation and what type of personal data that you process and the mandatory information. Mandatory information means this information. So when he sends that request, you have to necessarily respond to that and provide that information. And that is why the privacy notice is important. So if you are saying, OK, I'm processing your personal data, these are the types. With regard to mandatory information, please visit such and such, if the online reference is the appropriate mechanism. Right to withdraw the consent, where the consent is the appropriate lawful basis and where you have used it, he is entitled to come back and withdraw the consent at any point of time. It means after you receive that withdrawal, you can't process personal data for that purpose going forward. But it doesn't mean that any and all acts of processing that you have done up to this point will be unlawful. Up to the point of withdrawal would be unlawful. It only makes it unlawful if you process personal data after withdrawal. Right of rectification or completion. As I said, this is tied up to obligation of access. This is tied up to obligation of rectification and completion, accuracy and completeness. And so that the data subject is entitled to send a written request saying, my personal data is with you and this address is wrong. Its address has changed and here is my new address. Please change it. And when you receive that, subject to you verifying the identity of the person, you have to comply with that obligation and then you have to respond as well. Right of erasure. Data subject is now given the right under the law to cause you to erase his personal data under certain circumstances. Where he has withdrawn the consent is one of the instances. And where there is a mandatory legal requirement such as a court order. And the other very, very important thing that needs to be kept in mind, if you process personal data in violation of the parameters set out in the enactment, he is entitled to come back at any point of time and say you are processing information, even though for a valid purpose, you are doing it in violation of the law. And therefore, you must delete it. So if you don't comply, this is one of the dangers that you may face. Review of automated decisions. Now, there are instances where you deploy technology to make decisions. And if the entire decision is made, or rather the decision is solely based on automated processing, say for example, you set forth a particular system and that decide all by itself whether a particular application should be entertained or not. Another example, let's say there is a particular system, there are systems and online mechanisms that are available to figure out the PEP status, politically exposed person status. And if you make the decision whether a person is a PEP purely based on that automated processing, then that is what is called a decision based on solely automated processing. In that scenario, subject to this particular exception, which he is entitled to come back and ask you to review it. There it must be kept in mind. So sometimes, say for example, when you process applications, you may use certain tools, but at the end of the day, that may all amount to input before a particular officer who would be the making final decision. If that is the case, it's not a decision based on solely automated processing. If that is so, the only when systems or the AI makes the decision all by itself, then this particular right is applicable to the data subject, subject to this particular exception, which is likely to create irreversible and continuous impacts on the rights and freedoms of the data subject under any written law. It means if he can exercise this right to review only if the decision to be made by the automated processing would have an irreversible and continuous impact on the rights and freedoms of the data subject. A person who is more tech savvy might ask the question saying that what potential decisions that can be made which has irreversible and continuous impact on the rights of the data subject. Now that's a very valid question because this is something that we have uniquely put in our law, and I am not aware of single technology that is being deployed which has a irreversible and continuous impact. So probably with the regulations coming in, they might be able to elaborate on this, but for the time being, the scope of this particular exemption is a bit uncertain. And in any event, this right is not applicable where the solely automated decisions are permitted by written law or authorized by the Data Protection Authority, or the consumer has consented for automated processing, or necessary for the purpose of entering into a contract with the consumer, but not when you are processing sensitive personal data. Then the law also set forth how a data subject can exercise these rights and what you have to do upon receipt of such consent. He can send a written request. He has to send a written request. Written means here it can be by email as well, meaning electronic communications are also valid. So when you receive the request, you have two options, understandably, either accede to the request or refuse the request. You have been given limited grounds to refuse that. And where you refuse, you have to figure out whether it has to be a partial refusal or full refusal, meaning if you can't do, if he requests X, Y, and Z, and because X can't be done, you don't have the freedom to reject Y and Z as well. So then you'll have to do Y and Z, and with regard to X, you'll have to very clearly explain in the written communication that you are required to send back saying I complied with Y and Z, but X I can't comply for these reasons. And one of the grounds based on which you can refuse is you are unable to establish the identity after trying to verify the identity. Or there's a mandatory legal requirement such as the Financial Transactions Reporting Act requires information to be kept for 6 years. And he send the request within 6 years. Therefore, you'll have to go back and say, no, I can't comply with this because there's a mandatory legal requirement. Just another piece of information here that is important is that remember the privacy notice is critical here, because if the privacy notice, if you say I will be deleting it after 2 years, and then when he sends the notice after 2 years, you can't end up in saying sorry, I want to keep it for 6 years. So that's why getting it right from the day dot, at least the criteria, is very, very important, because you are in the privacy notice, you will be holding it out to the data subject. I will be keeping it for this time period. Technical and operational feasibility, this should not be lightly understood to mean that my current ERP system or the systems that I have set forth in that I have currently put in place does not allow deletion. That's not an answer. It means that after doing everything, after transforming the entire environment into a data protection compliant environment, if you are still there could be, due to technological limitations, 0.001 scenario where you're not able to do something. And that is the small window that you can use based on reasonable facts is what is couched here. So technical and operational feasibility. That is, after doing everything, there could be still exceptional scenarios where you may not be able to comply with one or two requests. You have to reply to the request within 21 working days, and you have to also inform in that response that he has a right to appeal to the data protection authority if he is not happy with the decision that you have made. With that, if you go to third-party data, that is to say the third parties that whose services you are obtaining. Here, the third party means not the processors that you are onboarding to help you in terms of processing personal data, but rather third parties with whom you have contracted, such as to, let's say, obtain security services or janitorial services, and in that process you have collected either the business or personal contact information of certain individuals. Then, with regard to those personal data of relating to the third party service provider, you are the controller. All your obligations that we have talked about and more to be discussed, all that would be applicable to that in relation to that data as well. Then third party service provider, here we are targeting processors, meaning, as I said, let's say you onboard a cloud service provider or payment gateway service provider or data analytics service provider, then you may end up in passing personal information, personal data that you have with regard to your customers or employees to these entities, or it may be stored on the cloud. In that scenario, you are onboarding a processor. So you have to therefore comply with the obligations of retaining a processor. And it's also important to highlight here, while you may be onboarding processors, with regard to certain business activities, you may be the processor. Say, for example, if you are the payment gateway service provider, you are the data analytics service provider, or you are the cloud service provider, or you are the payroll service provider, then you may be a processor, or there will definitely be activities with regard to which you are the processor. So if you first take the instance where you are onboarding a processor as opposed to you are the processor, your obligations are the enactment necessarily requires you to enter into a clear contract, and the certain mandatory information that needs to go into the contract is also set out in the law. And you have to also ensure that let's say if you yourself do it and you have to comply with if you have to comply with certain obligations as a controller, then you have to ensure all that is done by your processor, because everything he does, you are responsible. So if he does a mistake, you pay for the mistake. That's the danger of having a processor. And hence you have to ensure that any and all your obligations as a controller in relation to that data is duly fulfilled by the processor. So therefore, you need to necessarily assess the processor before you onboard to figure out, does he have the appropriate organizational and technical measures to process the personal data if I give it to them. If you are an IT service provider, you already know, and dealing with European companies, before they onboard you, they send you plethora of questions and sometimes even ask certifications such as ISO 27001 with regard to security, like that. That is all because they are the controller in European Union, and anything you do, they are responsible. That's why they are doing it, and that's the principle which has come here with certain modifications. Certain unfavorable modification, because unlike in European Union, processor has certain direct obligations under the law. Here also we have, but here it's diluted in the sense that entire burden is put on the controller to ensure that everything the processor does, you have to ensure that he's compliance with the law. So certain practical measures, try and have a very comprehensive indemnity clause in the processor agreement. And with the enactment comes into being, it's likely the insurance product will come out to protect yourself against the liability, because there's no point of suing the entity. And hence you asking them to obtain a certain insurance cover in your favor could be a practical measure due to the enormous, due to the high volume of due to the high scale penalties that may come in your way if the processor violates the data protection law. And with that in mind, if you are the processor, you are, compared to a European counterpart, you are in a better situation, because as I said, under the Sri Lankan enactment, only limited obligations have been imposed on you as a processor compared to your European counterpart. So, but you have to ensure that you do everything in accordance with the written instructions of the controller. And you have to ensure these are you have to also ensure your staff is governed by a obligation of confidentiality and secrecy by implementing appropriate organizational and technical measures. And you have to also facilitate controller carrying out any compliance audits to figure out whether you are a person who is in compliance with the requirement enforced by the controller. And you have to also erase or delete personal data upon completion and on the written instructions of the controller. Certain other aspects that you must keep in mind as a processor, if you are a processor, if you deviate from the written instructions of the controller, then enactment to that extent make you a controller for that information, meaning all the obligations of the controller to the extent of deviation will fall on you. So that's the danger of if you even deviate the written instruction, even for a small, even by a small margin. And if you are obtaining sub-processors, you have to also ensure that your obligations to the controller is naturally mirrored when you onboard a sub-processor, assuming you are allowed to onboard a sub-processor by the controller in the first place. Going to the third aspect, employee data. As we discussed already, there are a lot of purposes in relation to human resources, like personnel file, recruitment, payroll, performance evaluation, monitoring, disciplinary proceedings. And in all those instances, you may be collecting a lot of personal data. And when you do so, you are the controller, employer is the controller, and all the obligations of the controller with necessary modifications would be applicable to you. And certain things, though, with regard to this is a separate subject, if at all, but just to highlight few things that would be worthwhile noting. One is that there's a clear imbalance of bargaining power between the employer and employee. Therefore, consent is unlikely to be the appropriate basis with regard to almost any purpose between the employer and employee, except in a limited instances where now in the EU and the states you have this new principle of diversification and the inclusion, meaning to ensure that all genders are given equal opportunity. They collect information such as your LGBTQ status. Now that can be based on consent because he has the discretion to give that information or not, except in instances such as that, consent should not be used as a lawful basis when you process employee personal data, because remember the concept of consent there is absolute free will. Certain other important aspects, again, this is applicable as a controller. More obligations apart from what we have discussed so far. Data protection impact assessment, data protection officer, retaining third parties to process personal data, what you have to do, cross-border data transfer or data flow, direct marketing. If you take one by one, data protection impact assessment, this is like a evaluation, meaning sometimes when you do business decisions, let's say, for example, a board has to make a decision pertaining to a particular matter, and you want to evaluate as to whether this may be feasible or whether this may yield what you want. And in that regard, you may retain an appropriate person. It could be an auditor, it could be a particular assessor to carry out certain assessment and then give you a report as to the feasibility and the risks that are involved and mitigatory measures. And that's the concept that is integrated here. You may have also come across the concept of environmental impact assessment, where before doing certain sensitive activities, you have to assess the impact on the environment, mitigatory mechanism, report to the Central Environmental Authority. And again, that's the same concept that is integrated here. With regard to certain data processing activities, which the enactment set forth, before you do so, you must undertake what is called a data protection impact assessment, practically similar to doing a EIA or any other assessment to understand the full effect of that activity on the data subjects. And the instances where you must do so is where you do any activity which is which involves a systematic and extensive evaluation of personal data or special categories of personal data, including profiling, systematic monitoring of publicly accessible areas, and any activity process prescribed by law. Here, the systematic means anything sort of occurring according to a system, or it could be prearranged, organized, or methodical, or it could be taking place as part of a general plan for data collection. So it's not necessarily limited to an IT system. And say, for example, if you have 1,000 employees, it is likely that you would be processing special categories of personal data with regard to all 1,000 employees. And remember, it's also include systematic and extensive evaluation, include profiling as well. Profiling is defined in the enactment, processing personal data to evaluate, analyze, predict aspects concerning data subjects' performance at work. This is where your employee performance also get caught. Economic situation, health, personal preferences, interest, credibility, behavior habits, location movements, etc. So when you do, if you do any one of them, then you are doing profiling. And if it is systematic and extensive, then you would have to first do a data protection impact assessment. And then based on that impact assessment, design the appropriate organizational and technical measures. That's how it's get integrated into your compliance. You do a DPIA, data protection impact assessment, to figure out how should I approach this? How should I structure the organizational measures to ensure that the rights of the individuals are balanced, protected, and enhanced? And that's the purpose of doing so. And here even systematic, another example for systematic and another example for another example which may fall within, which may require you to do a DPIA is that let's say you are monitoring publicly accessible areas, such as you have a CCTV system, and at any given day you have 1,000 people coming in and going. And that means that any particular year you may have hundreds of thousands of people, movement, faces, and stuff like that is captured. So that's a systematically monitoring a publicly accessible area. It could be that your shop is open to public and you have a CCTV system. So you will have to figure out whether it's amount to systematic monitoring of publicly accessible area, and then decide if that is the case to have a DPIA, and then take necessary measures in that regard to protect that data, encryption, and all that. And after enactment comes into being, there could be specific activities that are, specific activities that may be prescribed by way of the rules and regulation which require DPIA. Further, it's likely there may be further rules and regulations that will be made under the enactment to define these other two parameters, systematic and extensive evaluation and systematic monitoring of publicly accessible areas. Data protection officer and This again is not a mandatory requirement if you fall within one of these categories. You are a large scale monitoring. If you do large scale monitoring of data subjects, large scale processing of special categories of data, processing which might have a risk of harm to the data subject. All these are fact sensitive questions. And the word large scale is not defined. That means there will be rules and regulations coming in. But to briefly explain, monitoring here, as I said, includes even CCTV monitoring or even internet tracking. Let's say if you monitor the internet behavior of thousands of employees, you may get caught here. And large scale processing, definitely each hospital will fall into this category. And banks may also have. And if you have a lot of employees, again, if you could fall within this second category again. Processing which might have a risk of harm to the data subject, that's a fact sensitive question, that if there is a potential harm, then how you figure this out is by way of a DPIA. You do a DPIA, figure this out. If there's a risk of harm in your core activities, involve activities which may have a risk of harm to the data subject, then you need to have a data protection officer. A freedom is given to the one group of companies to have one DP, data protection officer, and enactment also says that it will under the by way of regulations passed under it, the qualifications of the data protection officer may be prescribed. So whether you would need a data protection officer, as I said, will have to be determined only after looking into your activities. It's not an open question except few organized entities such as I said, hospitals. It will be always a fact sensitive question. And also bear in mind, you have to publish the details of the data protection officer in the privacy notice. And you have to also communicate the contact details to the data protection authority. Cross-border data flow. And this is the requirements coming here is in addition to any sectoral requirements. What does it mean? Now, let's say, for example, banking sector, you have much more stringent requirement with regard to cross-border data flow, which they recently introduced. And so those requirements are in addition to these requirements. So this is you have to comply with this and then also comply with the sectoral requirement. If the sectoral requirement have a much more stringent requirement, then after complying with that, you have to supplement the compliance with the additional requirement. With that in mind, cross-border data flow is practically any processing of personal data outside Sri Lanka. It also means, let's say, for example, you are anyway based outside Sri Lanka, you have a subsidiary outside Sri Lanka, and then they directly collect data online when the customer logs in or something like that. That itself amounts to a cross-border data flow. So when you are doing a cross-border data flow, or when your activities involve cross-border data flow, you have to ensure that the third-party country within which you will retain data is a country with regard to which adequacy decision has been made by the minister. The list is not yet published. It will be published by your regulations. That's the first thing you have to figure out. Whether is that a country, the country in which I'm processing data is a country which is published by the minister under the Gazette as a country with adequate protections for data processing. If it is not, then you have to do an assessment on your own to figure out, regardless of me sending, although it's not a country with regard to which adequacy decision is not available, I'm going to send the data to that country. But you can make that decision only if you are personally satisfied that regardless of my sending data out, I am able to comply with all my obligations under the data protection law with regard to those data that has been sent out to a country without an adequacy decision. And in that scenario, authority will also require you to enter into a separate instrument with the third party in that country without in that country which does not have adequacy decision, so that this added protection is given to the individuals, that regardless of sending data to that country, their rights and interests would be safeguarded. So in summary, yes, you can send data out. If you are sending it to a country with adequacy decision, apart from complying with obligations in onboarding a processor, nothing else to be done. If you are sending it to a country without an adequacy decision, you have to be satisfied that's a country okay to be sent, and you have to enter into a separate instrument that will be dictated by the data protection authority. And if we are not able to satisfy any of these requirements, meaning it's not a country with adequacy decision, it's not a country, it's being sent to a country, but you are not able to enter into a instrument which is dictated by the authority, then still you can send data out subject to these specific instances where you obtain explicit consent from the data subject, having informed him the risk of sending data out to a country like that, and is necessary for the purpose of performing a contract, establishment to exercise of a legal defense, public interest, emergency threatening life, or permitted under any conditions prescribed under PD Personal Data Protection Act. Evaluation of these conditions require more time, but for the purpose of this presentation, we are not going to go into these grounds, because as I said, application of these grounds, these grounds are applicable only limited instances. So on the face of it, it looks like when you have a contract, you can send the data out. That's not the case here. So these grounds will have to be separately evaluated to figure out whether you can use these grounds. Then coming to the concept of direct marketing, this is where a complete paradigm shift, another instance where a complete paradigm shift has taken place. Now, up to this point of time, whether you are a bank or restaurant or whatever it is, and we get SMSs saying, the 15% off, or you have there's a particular sale going on, and all that amounts to what is called marketing or sending marketing communications. With the enactment comes into being, it introduces this very stringent requirement, which is not even there under the GDPR. Even GDPR is a little bit more relaxed than this, meaning you can only send a marketing communication to promote goods or services or any entity. It could be your entity or it could be a third party, if and only if you have in the first instance obtained consent to send marketing materials of this nature, of the nature that you are planning to send, meaning you want to product, let's say sanitary products, promote sanitary products. But before sending any marketing communication, you have to first contact the data subject and ask his specific consent. Can I send you marketing materials or messages relating to sanitary products? If he says no, then you can't send any marketing messages. If he says yes, then you can. But also remember, at the point of seeking the consent itself, you have to tell him, okay, if you consent, this is how you withdraw it later on, by way of sending a message to us saying yes or stop or something of that nature, or click on this particular link and then you can go and unsubscribe. And then apart from that, each instance where you send the marketing message, you have to build in that opt-out mechanism. And only exclusion which came in the parliamentary committee stage amendments is where to this requirement is where you provide a free of charge internet-based service where the consumer or the customer has subscribed to something, and there are advertisement on that platform relating to the very service that you have subscribed. Or I think this what they have tried to capture here is the YouTube type of platform where it's runs on ad income, and they provide a free of charge service, and you subscribe to their terms and conditions and service. And if you say, get the consent before receiving marketing messages, the platforms like YouTube cannot work. So I think that's what they have tried to capture here and give an exception. Except that scenario, in any other scenario, everything that I explained is applicable. So With that in mind, few things that needs to be kept in mind though, which is that when you're onboarding a third-party marketing agency, remember that any database that they have up now could be a toxic database if they have not obtained consent of the customer to send marketing materials of the nature that you are planning to send. Meaning up to this point of time, when you retain a marketing agency, the fact that they have a 10,000 customer database is that's their asset. With the enactment coming into being, if you are a marketing agency or you are onboarding a marketing, remember that entire database is complete toxic or should not be used unless you have the consent of those customers to send promotional and marketing materials of the nature that you are planning. So you can't also obtain a one blanket saying, please give me the consent to send any marketing materials under the sun. It has to be tied up to certain purposes. Say, for example, let me send you marketing materials in respect to hotels and or the hospitality sector for these purposes, like that. So you will have to, if you are to obtain consent, you will have to obtain consent for the relevant aspect of the marketing. And if you have not obtained that, then your entire database is useless to you as well as to your consumers. That is from the perspective of a third-party marketing agency. So from a person who's onboarding a third-party marketing agency, please ensure that you do that assessment, because otherwise when he send marketing messages to a consumer without consent, because you have onboarded a processor, you will be liable for actions of that particular processor. So then again, because of the exposure you have, please consider as practical measures having an indemnity and insurance in place against those activities, or ask the marketing agency to provide the indemnity and the insurance. With that in mind, as this enactment provides plethora of obligations, obviously it provides for setting up a separate authority, and it empowers it. And to talk about this, and this authority is called Data Protection Authority. And to talk about it, I invite my colleague Amanda. Amanda, over to you.
Thanks, Shanaka. So as Shanaka mentioned, so as Shanaka mentioned, the Data Protection Authority is established, and it's the objectives of the authority include regulating processing of personal data, safeguarding the privacy of data subjects, and providing protection for personal data used in digital transactions and communications. The powers of the Data Authority include issuing directives, making rules, and looking into complaints and conducting inquiries. An inquiry can be conducted on 2 occasions. It could be pursuant to receipt of a complaint by a data subject, or the authority on its own accord could commence an inquiry. Once an inquiry has commenced, you are given an opportunity to present your case, and thereafter the authority will make a decision, and it can issue directives requiring you to either cease and refrain from engaging in the act, or take actions to rectify the situations, or to make a payment. If you fail to comply with the directive, penalties will be imposed. Failure to pay the penalty, if you fail to pay the penalty, it could be it could be a fine. There could be a fine imposed. The law will come into, even though the enactment has been passed, there has been a transitional time period that has been provided for the same to be enforced. Data protection principles, rights and obligations will be brought into operation in 18 to 36 months from the 19th of March. Then use of personal data to disseminate unsolicited messages will be brought into operation in 24 to 48 months from the 19th of March. The Data Protection Authority will come into, will be enforced anytime before parts 1, 2, and 3 are brought into operation. With that, we've concluded the presentation. And if there are any questions, I saw there are some questions on the chat box. Over to you, Sham.
Thank you, Amanda and Shanaka, for that very comprehensive discussion and presentation on the PDP Act. Some questions have come in and I will direct them to Shanaka. So the first question is, does the cross-border restriction apply to all companies or only to public entities? How would this apply to distributed storage computing systems such as, I'm not sure whether I'm pronouncing it correctly, Ethereum blockchain?
There are two aspects of it in that question. The first one is whether it's applicable to public authorities only. No, it's applicable to public authorities as well as private sector. Public authorities, there's in fact a mandatory obligations. In fact, application of the cross-border data flow obligations vary. They have much more stringent requirements. What I presented to you is what is applicable to the private sector only. And so therefore, regardless of the type of activity, if it involves a cross-border data flow, you must comply with these requirements. And if you are a processor, then as dictated by your controller, if the controller in the first place allows you to send the data out, but if you are a controller himself, then you must determine you have to first figure out, as I said, the adequacy decision, whether it's a country with an adequacy decision. If it is not, then you have to do assessment on your own, and then also enter into a instrument that will be dictated by the authority. If you do not fall within any of those instances, then you have to use one of the exceptions. Very limited those grounds are subject to very narrow interpretation, and subject to those only you can send the data out. So to answer your question, it doesn't matter your particular industry as such.
The second question, Shanaka, how would this apply to distributed storage and computing systems? Such as
it
Ethereum,
depends on the what is, can that person explain to me whether is he some a person who is providing this service to other third parties, or there are certain aspects when you are in that particular industry that you are doing stuff as a controller. If you can explain to me, then I can give you a more customized answer.
Imesh, if you're here, could you just clarify, please, so that Shanaka can answer your question?
Okay, I'll try and give a broad answer, but basically, let's assume what you are saying, what you are referring is to something like a data center, as for an example. And if that is the case, with regard to certain aspects, again, you are a controller, but most likely scenario is that you could be a processor, because you would be providing your services to third parties. And so in that regard, your obligations by and large under our enactment would be limited to following instructions of the controller. And other mandatory obligations are those that are explained in the presentation. Those are limited obligations like the confidentiality, the principle, and ensuring not to ensure that not to deviate from the controller's obligation, because if you do so, then you become a controller to that extent.
Okay, thanks, Shanaka. So we move on to the next question. What are the obligations of Human Resources Division in gathering employee information?
I think that's one of the aspects that we covered in the presentation. You are a controller, so you have various purposes with regard to all of which you will be the controller. And sometimes some of those activities are outsourced, such as payroll. And in that scenario, you have onboarded a processor as well. So the entire gambit of what I explained in this presentation is applicable to you.
Right. And the next question is on cross-border transmission. Would encryption and anonymizing data sufficiently to prevent relating to a natural person prior? Is it a workaround basically prior to transmission on a cross-border basis?
Yes, the short answer is yes. If you anonymize data, you can prevent the application of the entire enactment. That's a short answer.
Perfect. So we have another question. Can you explain the nature of obligations when considering insurance company, when considering a insurance company as a controller under the PDP Act? Industry specific question.
That's Himali, basically what he or she is asking is whether how the enactment interact with in the insurance sector, right?
I think so. Is there anything specific, or what you told earlier would all
because
of it?
as I said, the sector-wise, actually, insurance sector targeting that we did a presentation inviting all the insurance companies. So there, what we did is we took these obligations and showed how it applies to insurance sector. So everything we have discussed here is applicable to insurance sector as well. But how it particularly interacts with the insurance sector as such, that's a separate discussion. And the same, but short answer I can give you, everything we have said, all the principles without exception is applicable.
Right. Hope that clarifies, Sanjeevani, your question. So the last question on the more coming in. So the next question is any insights on what is meant by issuing licenses for regulating identity management and related services?
That we don't have exact information for the time being, but based on GDPR, what we can do is offer some guidance. I think what they are trying to do is they are trying to regulate issuing of identity cards and similar aspects like the NIC and or private businesses engaging in similar business. I think that's what they are trying to regulate. But obviously, once the regulations comes in, only we may be able to give you a more comprehensive answer on that.
Okay, so the next question is, how will this law prevent the use of unauthorized or the unauthorized use of personal data of natural persons without consent?
If we are doing I need to understand that question a little bit more, but assuming if what you are trying to ask is if you do unauthorized access, what would be the repercussion? If you are doing unauthorized access, it's very important to note that, let's say, even as an employee in the organization, you are not given access to a particular set of information, and you access that information without the employer's consent, then what happens is you do the fundamental mistake of becoming the controller for that information, meaning you are processing information on your own without the authority of your the employer in violation of the access control. Then you in all the obligations of a controller under the law become applicable to you. That's the danger of accessing information without that security clearance or without the authorization. In other words, employee is considered as part of the organization or part of the controller if and only if you are doing it within the boundaries set forth by the employer. If not, you become a third party which process personal data on your own, then all obligations become your obligations, personal obligations.
Shanaka, I think the question was raised from the perspective of a data subject. If there is unauthorized use of personal data of a data subject, how will the enactment prevent it?
That's what I said. That's the because how it prevents it is that that person who does the unauthorized access becomes the controller. So if you are the controller, if you become the controller, you would not want to access that information. That's one way of addressing it, because then you become directly responsible to that particular customer or the consumer or the data subject as a controller if you do unauthorized access. And apart from that, if there is a violation, that if that unauthorized access happens, that the access restriction is not appropriate under the circumstances, then that controller is also responsible for not having appropriate technical and organizational measures to ensure that access control. So that those are the two aspects of it. So it's the data subject is given protection in that way. On one hand, he has a cause of action against the controller to whom he originally gave the information. On the other hand, he has information the right against that other person who got the information to go after him as a controller.
Right, understood. So the next question is on ERP systems. He says typically data has to be retained for a stipulated time period. And if part of this data is removed, that would lead to an inconsistent database. How does the Act apply here?
Yeah, so now that's a good question. Now the ERP systems with the GDPR came in most of the number of ERP systems. If you take Workday, if you take Gigia, and especially now one of the very famous one is Workday. Now they are GDPR compliant. What does it mean is that given the GDPR requirement, those solutions providers, they revisited their systems and allow GDPR the customize it in such a way, depending on the country where it is deployed, you can the customize it so that you won't be in violation of the personal data protection law. If I give an example, now when you with the enactment comes into being, you need to have a retention time period for each of your activity. Let's say employment record. So the ERP system such as Workday, at the point of deploying itself, you can customize for this particular record. This is the retention time period. So if your ERP system does not provide for that, that is why the transitional time period is given. You have to transform your ERP system in a way that it will not violate data protection law. That is why I specifically said you can't use the ERP system as an excuse to violate the data protection law. ERP system has to be modified, not to use, and you should not use that as an excuse not to comply with the data protection law. So the one practical measure is that there are already the internationally, at least the acclaimed solutions are already GDPR compliant. If it is GDPR compliant with minor modifications, you can use that solution in Sri Lanka and overcome the very issue that you highlighted.
Okay, so I think there's further clarity on that previous question of unauthorized use of personal data. So the participant asks if the data is shared with marketers to promote products by the controller basically sharing personal data to marketing companies without the consent of the data subject. What is the law enforcement scenario in? Yeah.
Right. So now that in that scenario, now remember in the mandatory let me go back and just right. Now remember this mandatory information that needs to go into the privacy notice. One of the items is recipients and third parties with whom personal data may be shared. So in the particular example of marketeers, right? Before coming to that, when it comes to you sharing information with third parties, first, you need to have that itself is a separate activity. That's the first thing that you need to keep in mind. that itself is a separate activity pertaining to that personal data. What does it mean? Now you have a identified purpose, sharing information with a person in this particular sector or entity in that particular sector. That's the purpose. So for that, you need to have a lawful basis. If you are sharing information with a marketing entity, the lawful basis is consent. So you cannot share with a third-party marketing entity saying, okay, I have this information. This happens in Sri Lanka at the moment very widely. That's why I think the question is relevant, where the lot of entities end up in sharing information with the others saying, okay, you send this off. Here I have information about this person. He has this much of wealth. You might be able to sell you this particular product to this person. Now, with the enactment comes into being, that's completely unlawful. You violate the law and you will be responsible. And you may, even if you don't, then you may be facing directions coming from the authority. If you fail to comply with the directions, you will have penalties coming in your way. Each instance of violation, it can go up to 10 million rupees. So that's completely unlawful if you don't have if you have not obtained the consent of the data subject to share the information that you have with regard to this particular data subject with the marketing agency. So the consent would be the appropriate lawful basis there. And let's say, for example, now another third party with whom you can share personal data in that context is insurance companies. Insurance companies where, say, for example, you want to obtain the corporate insurance for your employees. Now there, the consent would not, you don't need to obtain the consent because it could be mentioned under legitimate interest. Because you have a legitimate interest of ensuring that your employees have a proper adequate insurance. So then you will be sharing the information with that third party using that lawful basis. But for the marketing purposes, you would definitely need the consent. If without the consent, if you do so, you are doing an unlawful activity.
Thank you, Shanaka. A question that just occurred to me is, can you enforce your rights as a data subject without the intervention of the data protection authority? Is there a right of recourse?
Yeah, that's all the rights are. Anyway, you are enforcing it against the controller in the first place, asking for information. Again, that previous explanation that I provided, let's say now they unlawfully share the information with a third-party marketing agency without the consent, then in the first place, that controller has done a serious violation. Apart from that, the marketing agency who gets that information, now they are a controller anyway. So they are anyway separately responsible for that data subject for all the information that they got as a controller. So the data subject on one hand has a cause of action against the current controller who unlawfully shared the information, and then has all the rights that is available under the law against that marketing agency for being a controller of his information due to the fact that they obtained that information to their hand.
Okay. The next question is on banking. If a bank to process personal data of a child, for example, by facilitating children's savings accounts with the consent of the parent or legal guardian, do they need to obtain fresh consent from the minor upon the child enter?
No, the consent they are in the enactment, in the consent that is referred to in the enactment in the context of a child means this enactment specifically provides for either parental consent or the legal guardian. So that's if you have obtained the separate consent of a legal guardian to a parent, you don't need to. But you may want to revisit that consent form to figure out whether that consent form is in line with the data protection consent requirement. Remember, it's not just if you had built it into your normal terms and conditions, there may be a problem there. So the one of the things that happens even when you have a consent of the customer, if the consent is the appropriate lawful basis, even when you have consent, the problem is because in a non-data protection compliant environment, you would not, you may not have ever considered the consent requirement of a in the data protection context. So while you may not need consent again, yet you need to still go back and review those consent forms or documents to figure out whether other formalities pertaining to the consent is upheld or are upheld with regard to that particular consent that you have obtained. That you have to anyway do.
Right. Thank you. Looks like we don't have any further questions. Is there anything anyone wants to raise quickly before we come to the end? I think that's all. Shanaka, thank you very much, and Amanda for that comprehensive discussion. And I also wish to thank the Sri Lanka Institute of Directors for giving us this opportunity to collaborate with you and make this presentation to your members. And thank you all to all the participants for your participation. I wish you all a good evening and a pleasant weekend. Thank you.
Thank you all.